Hopefully we can get done on time, or at least before the Jayhawks play at 8:40 tonight. We won't take that long. 3 bill hearings. First one, I'm going to open the hearing on Senate Bill 56 and ask Natalie to give us overview.
Thank you, Mr. Chairman. Senate Bill 56 requires the posting of human trafficking awareness notices approved by the Attorney General at certain businesses and public places. The bill amends KSA 75-759. That's the statute that requires the posting of a notice offering help to victims of human trafficking to be accessible on the official website of the Attorney General, the Department for Children and Families, and the Department of Labor. This bill would maintain that requirement. The current law also provides that the notice may be posted in a prominent and accessible location in workplaces. The bill would require posting of the notice in places required to post notices under the Kansas Act Against Discrimination, the Kansas Age Discrimination and Employment Act, the Kansas Child Labor Law, the Employment Security Law, or the Workers' Compensation Act. The bill would also require that notice to be posted in a location that's visible to members of the public and sexually oriented businesses, massage parlors, healthcare facilities, convenience stores, and truck stops, as well as rest areas and visitor centers under the state supervision or control. And then the bill would also require the Attorney General to adopt rules and regulations prescribing the content, the size, and other characteristics of that notice as the Attorney General would deem appropriate to help support victims of human trafficking, including information regarding the National Human Trafficking Hotline. And that would replace the current language of the notice that's required there in the statute under current law. And I can take any questions.
Thank you, Natalie. Representative Carmichael with a question.
Thank you, Mr. Chairman. This legislation seems familiar. Have we seen it before?
Mr. Chairman, Representative Carmichael, you have. Last biennium, this was Senate Bill 371. It made it through the Senate side. It was not amended over there. It came to you all, and you guys had a hearing on it on March 11th, and then it died in committee.
That's helpful. Thank you. One other question with the chair's permission. I note on page 2 at line 13, it provides the notice described in this section shall be made available in English, Spanish, and if requested by an employer, another language. And it says by an employer, not the employee. Is there any provision in here that requires any of these notices to be posted in any language that is common to the continent of Asia? The answer, I think, is no.
Yeah, Mr. Chairman, I believe the answer is no as well.
Thank you.
Do we have any other questions for Natalie? I'm going to have to start looking up now that our committee room's starting to fill out and you're not all on my screen. Any questions? Okay, we will move on to proponent testimony. And Jennifer Montgomery, I believe, is online.
Yes, I'm here.
There we go. You're up, Jennifer.
Thank you very much, Chairman Patton and members of the committee. Thank you for the opportunity to offer this testimony in support of Senate Bill 56. I'm here today representing the Human Trafficking Advisory Board. Each year, this multidisciplinary board makes legislative recommendations. This is one of them that we made last year, as Representative Carmichael pointed out. We are again recommending this piece of legislation. There are no changes to the bill from the bill that you saw last year. You all have my written testimony. I did want to point out a couple of things. Current law encourages businesses to post this information. Passage of Senate Bill 56 would make this posting mandatory. Human trafficking has been reported in all 50 states. Both forms of trafficking, sex trafficking and labor trafficking, exist in both rural and urban areas of our state as well. The National Human Trafficking Hotline keeps data each year on calls coming in from each state. In my written testimony, you can see the most recent full year statistics from Kansas. The calls are pertaining to both labor and sex trafficking. Those calls come in from members of the public who have perhaps witnessed something that appears to be trafficking, as well as from victims of trafficking who are wanting to be connected with services. When a tip is called in to the National Human Trafficking Hotline from Kansas, we have a state protocol. That tip is then routed to a designated staff person at the KBI and our other state and federal law enforcement agencies for the appropriate follow-up and assignment. Posting this hotline number is important, number one, to provide tips to law enforcement for follow-up, but also, as I mentioned, to connect victims and survivors of sex and labor trafficking with services to help them stay safe and to help them heal. As Natalie mentioned, our office does provide these posters currently. They are free of charge. They can be downloaded for printing on our website. We're recommending posting this hotline in certain businesses and public places, much like other states already do. Some of those states include Missouri and Arkansas. With that, I will stand for any questions that you have or other members of the committee.
Committee, any questions? Do not see any. Thank you very much. Committee, you have written proponent testimony from the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and the Kansas Peace Officers Association, from Fuel True Independent Energy and Convenience, from the Johnson County Sheriff's Office, from the Kansas Catholic Conference, from the Kansas Hospital Association, and from the Topeka Shawnee County Anti-Human Trafficking Coalition. Anyone else here or online as a proponent? Don't see any. What about neutral? Any opponents? Okay, we will close the hearing on Senate Bill 56, open the hearing on HCR 5014, and go back to Natalie.
Thank you, Mr. Chairman. House Concurrent Resolution 5014 would propose an amendment to the Kansas Constitution to provide for legislative oversight of administrative rules and regulations. If passed by 2/3 of the members of both the House and the Senate, the people of Kansas would vote on a constitutional amendment to provide that whenever the legislature has authorized an officer or agency within the executive branch to adopt rules and regulations, the legislature may provide for the revocation or suspension of any of those rules and regulations on a majority vote of the members of the House and the Senate. If this resolution were to pass, then the election on the constitutional amendment would be held at the general election in 2022, unless a special election would be called at a sooner date by a concurrent resolution of the legislature. And I can take any questions.
Questions for Natalie? Do not see any. We'll start with proponents, and first up is Derek Schmidt, Attorney General. Yes, sir.
Thank you, Mr. Chairman. It's like committee testimony in the round here. We're surrounded by. Mr. Chairman, thank you for conducting this hearing today. You have my written testimony, and we have other conferees. I won't belabor things. Let me just kind of maybe frame up from my vantage point at least how we got to this recommendation and what we're trying to accomplish, and I'd be glad to kind of take your guidance on where to go from there. So, you know, I'm sure we'll all look back on the COVID period and say, look at the things we've learned. And this has, by the way, nothing to do with COVID or anything, but we've learned because of COVID that Kansas used to have on the books something called a legislative veto. And the concept is pretty simple, that when a regulatory agency promulgates a regulation, that the legislature had the authority by a concurrent resolution to reject or suspend that regulation. That was the concept. It's actually a fairly old concept. I came across some academic literature that suggests, I haven't yet been able to prove it, so I'm not prepared to assert it. I'm just relaying what I read, that Kansas was the first state to adopt a legislative veto back in, I think it was 1937. It was in the late 30s. I haven't yet found the proof of that. There were about a dozen states that had legislative veto laws on the books up until the 1980s. The federal government had more than 200 examples of legislative vetoes built into federal statutes. They didn't have a general overarching authority, but they built them into specific statutes. Really, the idea was born in the 1930s when the regulatory state was born, when the so-called alphabet soup agencies of the Roosevelt administration started to exist. Now they look small in hindsight, but at the time, it was this new fourth branch of government concept. And policymakers asked, how are we going to ensure oversight and a check and balance over their rulemaking, which from a citizen standpoint has the force and effect of law. It's not different in its effect from you all passing a statute. And they came up with this legislative veto mechanism. And then along came 1983, when a plaintiff in the federal system challenged a federal legislative veto statute, and the U.S. Supreme Court ruled that under the federal Constitution, they're not permissible. They don't satisfy the presentment clause. It's a separation of powers issue, essentially. So the federal legislative veto was struck down. And quickly after that, in the roughly a dozen states that had state-level vetoes, similar challenges were brought, and all but one that we've been able to find, at least, met the same fate. Kansas legislative veto statute was struck down in 1984 in Stephan versus House of Representatives. The only state we have found so far where their statute survived scrutiny at that point was Idaho. And for whatever reason, the Idaho Supreme Court came to a different conclusion than every other court of final resort that looked at it, upheld their statute, and it's still on the books today. And as far as I am aware, it's operated just fine through that period. Once all of these state statutes failed by court order in the 80s, there were some states that essentially said, you know, we like that idea. It's good public policy. We ought to have that type of check and balance. And so we're going to put a constitutional amendment on our ballot for our voters to decide whether they want to remedy the constitutional defect. And we have so far located, I believe it's 5 states that did that: South Dakota, Iowa, I believe Michigan is one, Connecticut, New Jersey are the ones I'm aware of. So they plus Idaho have these tools. There may be others. I don't want to represent our research as exhaustive. Those are the ones we found. So anyway, we came across all this, doing research in dusty law books over the last year, and thought that's a pretty good idea. And that was the origin of this suggestion. The recommendation in 5014 before you today, if adopted, if you all approve it and it goes on the ballot and the voters approve it, it's permissive, doesn't require the creation of any legislative veto statute. You all would then, if it were adopted, have to follow up with implementing legislation, and there'd be, I'm sure, plenty of details to be hashed out. You might want to put boundaries on it or deal with some subject matter or other important issues. But you don't get to those discussions without the authority to do it at all, which is where we are today. So that's how this came to pass. As we took this idea and have shared it with others, it's been warmly received. I've been pleasantly surprised, so much so that what I thought was going to be an issue for perhaps next year, it's now an issue for this year, because the response has been, seems like a good idea, let's air it out, and if it is, let's go. The only other thing I'd add, Mr. Chairman, and then I'd either stand quiet or stand for questions, even in Kansas today, post-1984, the concept of a legislative veto is not foreign to our system. That's what the executive reorganization order provision in the state constitution provides for. Now, it's not identical to this, but it's the same concept, where you can have an executive action and the legislature may reject it without presentment, and in that case, without bicameralism as well. This proposal you'd have to at least have both houses rejecting. So with that, Mr. Chairman, I'd be glad to either stand for questions or stand aside. That's what the idea is, and thank you for taking time to hear it.
Very good. Committee, let's go through all the proponents, and then we'll come back for questions in the event. We've got a number, and maybe you'll answer some of the questions before we get to them. So next we have Alan Cobb.
Thank you, Mr. Chairman. I'm Alan Cobb, President and CEO of the Kansas Chamber. We represent medium, small, large businesses of all industries in all areas of the state. Just a few years ago, we worked hard with a number of other associations and legislators to pass something similar to what Wisconsin has as the REINS Act, which, to summarize, put some economic impact analysis into regulations. We wanted to include a provision of a legislative veto, but we're told because of the Stephan case of the Attorney General reference, we could not. Ultimately, that legislation passed. So we support this as a way to restore some of the legislative balances, part of the regulatory process, and it's fairly simple. I think the Attorney General did a terrific job giving some history and why it's needed, and will stand for questions at the conclusion of the proponents.
Very good. Thank you.
Thank you.
Next, we have Elizabeth Patton.
Hello, my name is Elizabeth Patton. I'm the State Director for Americans for Prosperity Kansas. Thank you for the opportunity to testify today. We believe strongly in an economy that works for everyone, where people can succeed and live meaningful lives. And we believe a big part of that relies on some government accountability as well. So we believe that the government has a role in creating fair and equally applied rules that foster an opportunity-rich environment for all people and protecting public harms, but that role should also be limited and critical that it's not onerous or unnecessary. So we just believe that over the decades, and I won't reiterate some of the history that you just heard from the previous conferees, so I'll skip over some of that, but we believe that those things have ultimately created a little bit of an imbalance of power in an otherwise pretty balanced system here in Kansas, and that we lack the appropriate mechanisms for accountability. We believe that we've given some broad power to create legally binding restrictions and requirements, which means Kansans and even Kansas lawmakers like yourselves, we frequently or often end up with public policy that we don't want or need, perhaps. That was even perhaps created without representation. So we do believe that in order to restore the checks and balances, we do believe that this constitutional amendment is a necessary step in that direction to restore some balance to Kansas and help Kansas public policy in the future be as effective as possible. I would be happy to stand for questions this time, or when appropriate. So thank you.
Thank you. Ron Sieber.
Chairman Patton and members of the committee, I am Ron Sieber, President and CEO of the Kansas Grain and Feed Association, the Kansas Agribusiness Retailers Association, and Renew Kansas Biofuels Association, and I stand here in support today of House Concurrent Resolution 5014. KGFA is the state association of the grain receiving, storage, processing, shipping industry in Kansas. KGFA's membership represents 99% of the commercially licensed grain storage in the state. CARA is a trade association with over 700 agribusiness firms that supply fertilizer, crop protection products, seed, petroleum products, and agronomic services for the Kansas farmers. And Renew Kansas is a trade association that represents the Kansas biofuels industry. So I've got a lot of folks I'm representing today. And broadly, the members of all of these associations operate in agribusiness industries, which are both important and highly regulated. Members of our association support state and federal regulations that are necessary, reasonable, and lawful. However, we have long opposed the adoption of regulations on the industry which are unnecessary or unreasonable as to scope or cost of implementation. Each executive branch authority is created by the state legislature, as in the agency's scope of regulatory authority. Because regulations have the full force and effect of law, the process of adopting regulations should be deliberate, fully transparent to the regulated industry. As all authority to create law rests in the legislative branch of government, it is our position that the Kansas legislature should maintain final lawful authority to review and approve or deny the adoption of any rule or regulation proposed by an executive agency. This regulatory authority reflects the separation of powers within our state constitution and is consistent with how our state and others viewed agency regulatory authority for many years. This resolution seeks to make positive changes to the regulatory system in Kansas by providing oversight of proposed regulations by legislators directly elected by the residents of Kansas. For the reasons stated, we stand in strong support of HCR 5014 and ask the committee pass this resolution favorably. I'd be happy to stand for questions at the appropriate time, Mr. Chairman.
Thank you, Ron. Next, we have Aaron Popelka.
Thank you, Mr. Chairman, members of the committee. Aaron Popelka with the Kansas Livestock Association. I'm not here often, so I might just take a second to explain. The Livestock Association represents livestock interests across the state, all the way from your cow-calf operations, feedlots, We also have some swine and dairy producers as well. We generally support legislation that would reduce regulatory burden on producers. We see the House Concurrent Resolution 5014 as a way to do that. I think, since we've been a state, we've grown our statutes and therefore our regulations considerably. And from time to time, the executive does, I think, get beyond the scope of what the legislature meant. And so we see HCR 5014 as a very precise mechanism when we have an issue with a specific piece of regulation to go in and say, no, that's not what we meant. Please start over again. As the Attorney General mentioned, it's necessary to do this because of the case, the Stephan case in '84. But again, we think this is very narrowly tailored to achieve, those instances where the executive exceeded what the legislature sees as its original intent. So thank you, Mr. Chairman, and stand for questions at the appropriate time.
Great, thank you. Let's see, committee, we have written proponent testimony from the Kansas Cooperative Council and the Kansas Bankers Association. Anyone else online or in person here as a proponent? Okay, let's do questions. Representative Carmichael.
Thank you, Mr. Chairman. If the Attorney General is still available, I have just a couple of questions for him.
I am, Mr. Chairman.
Good afternoon, Mr. Attorney General. Good to see you again. First, I want to express my appreciation to you for the historical perspective. What you reported is entirely consistent with my own research, and so it's very helpful, and I appreciate your work to educate the committee. Along with that educational role, I would like to inquire of you about your role presently in the administrative regulation process. I've had either the fortune or the misfortune, depending on how you interpret it, of serving on the committee for about 4 or 5 years now, and I'm such a nerd I actually enjoy it. But sometimes folks come before the committee and they observe the presence of your approval stamp on a regulation, and then they infer that this represents your endorsement that this is in fact a good idea. And sometimes we even hear people mistakenly say, well, the Attorney General supports this idea because they see your stamp approving it. Could you explain to us what the criterion is and what your role presently is in the rule and regulation process? Because I assume there's a lot of times that you stamp things that you personally might not think are a good idea, but the law requires it.
Representative, yes, I'd be happy to. The current process, the Kansas Rule and Regulation Filing Act statute is, of course, the base statute that sets out the rule and reg adoption procedure in Kansas. It provides, it's a multi-step process from the agency that originally drafts and promulgates the rule. It then has to obtain several clearances. You all added a clearance or a hurdle a few years ago for certain rules or regulations that might be costly, that now there has to be a budget office review and sign off on that. It goes through the Department of Administration, and then it comes to us as part of that process. And by statute, our role is solely to approve the regulation, the proposed regulation, for legality. So we don't review the policy, to your point, which I appreciated your making. We don't review the policy. We don't express an opinion on whether it's a good, bad idea. We simply review the authorizing statute, the proposed regulation, and stamp it approved if we conclude that there is legal authority for the agency to regulate in the manner that it proposes. And often that becomes a back and forth process between us and the agency proposing the regulation before you would ever see them on the back end at the Rule and Regs Committee, which is sort of the final stop on the train, if you will, or the near final stop on the train before publication and implementation. A lot of times our attorneys will look at a draft regulation and they'll say, well, this needs to be changed, that needs to be changed in order to comply with statutory authority. And we'll go back and forth with the agency on that and ultimately reach an accommodation that we're comfortable is legal before we stamp it.
Actually, Mr. Attorney General, on those years where I'm ranking member, I do get to see part of that back and forth because your office is courteous enough to send me a copy of the letter that says, for the reasons we've previously discussed, we cannot approve your regulation. At least it gives me a heads up that something's going on, so I appreciate that effort. In your testimony, you explained to us, or at least alluded to, the process by which we consider executive reorganization orders, or EROs. And a different way that, at least currently, though, that we accomplish the purpose is, legislator, if I didn't like a bill that allows hunting at night by spotlight, or excuse me, a regulation from wildlife and parks, then I introduce a bill to repeal that regulation. Now, sadly, that particular fine legislation died a turnaround, but we have a statutory process now to say, King's X, you can't do this. This amendment would implement additional authority. Are you contemplating that we would have enacting legislation or something to set up a process to know whether we handle this like an ERO or whether we handle it on an ad hoc basis? What suggestions would you have for us?
Yeah, Representative, yes is the short answer to the question, which the bottom line I understand to be, would there need to be implementing legislation that would set up process and any other what I've called down in the weeds issues that would no doubt have to be sorted out here. The constitutional amendment would be necessary to clear the current constitutional impediment to having such legislation. But in the event it's adopted and that impediment is cleared, it still would fall to the legislature to decide whether to adopt implementing legislation, and if so, what that process would look like. And I would imagine that, you know, as we get down the road, if this proceeds, you know, there'll be probably a lot of considerations that you'll want to weigh in implementing legislation. I can't even foresee what they might be at this point. Some of the states that I mentioned that have constitutional provisions, I've looked at those, and some of them have very detailed prescriptive rules in their constitution. Not unlike we have detailed prescriptive rules in our Constitution as to executive reorganization orders. What we've suggested here is different. Just enable this to exist and then allow the legislature to work out the process, to your point.
And finally, Mr. Chairman, I want you to know, by the way, that we're batting 100%. We've been in complete agreement thus far, Mr. Attorney General. So let me give you one more question. It's been my observation, it has been my observation that before a legislator runs for governor, they typically support legislation to rein in rulemaking authority. But once a legislator, and I don't know if it's true over at your office, but once someone files for governor, then they tend to see these this type of legislation as an undue constitutional restraint upon the power of the executive. Would you care to address the issue, or would it be best that we move on to the next matter?
Representative, I can't tell you how grateful I am you asked that question. And
I'm always here to help you, Mr. Attorney General. You know that.
I do indeed. All I would say about that is this. This proposal, if adopted, would apply to any executive branch regulating entity. That includes the Office of Attorney General. We do issue regulations under current authority. So both today and perhaps in the future, I think this is a good idea.
Representative Heiberger.
Thank you, Mr. Chair. A couple of questions with your permission. First one for the Attorney General. Thank you for being here today. Now, it's my understanding of the regulation process that the executive agency does not have any authority that's not delegated to it by the legislature, and that the reason that we do that is because we here in this body don't have the time or the expertise to get into all the details of the policy questions generally. And after we do that, then there's an extensive hearing process, sometimes multiple hearings. I've actually served as a hearing officer in a number of cases, and then review on several levels. And so it seems to me that there are already existing a couple of ways to deal with the issue that's brought up here. One would be a more careful drafting of our legislative delegation, or going into more detail in the statutes that we draft. And then there's judicial review, that any time someone is aggrieved by If they think we've exceeded, or if they think the agency's exceeded their bounds, they can go to court and have that struck down if it has done so. And so why are those two other remedies not adequate?
So, Representative, it's certainly true that by more narrowly tailoring delegation of either legislative power or what the courts call administrative power that you and I might look at and think that's legislative power, the ability to make a regulation with the force and effect of law. It is certainly true that by more narrowly tailoring the delegation, you can have greater control over how the agencies, what they can do, their scope of discretion. And I would recommend that. But it's also true that even at that, there are times when an agency, through no ill will, but it simply may see the world differently than what you thought you were doing when you delegated authority. And at this point,
Because our statute was vague?
perhaps. I had a friend who was a copy editor one time, and his favorite expression was dare to be deliberately vague. When an issue's hard, just punt it off to somebody else and let them sort it out. You know, you're now in the position of amend the statute that delegated the authority. And that may be a good idea in some cases, but it's a relatively blunt instrument. Perhaps the concept here is a more precision way to say that's not what we wanted you doing with the authority we thought we gave you. That's the concept. With respect to the judicial remedy, you're right, of course. A person aggrieved who thinks that there's a legal basis for being aggrieved by a regulation can challenge it. Of course, I would hope that those would be few and far between because presumably we've approved it for legality and there's not a legal defect, but I understand the point. That obviously can be cumbersome, time-consuming, and expensive for a challenger. And if there's agreement here by a majority of both bodies that that regulation shouldn't stand, that seems to a streamlined process. That would be my thought on it.
I guess if I may, were you involved in the drafting of this legislation?
Yes.
And I guess my question is about the date that it will go on the ballot. I mean, earlier this year, we were assured that August of 22 was an excellent time for a constitutional amendment to be on the ballot. And why was November of 22 chosen in this case?
So, Representative, believe me, perhaps the hardest issue in this was not the substantive policy. It was, you know, you got to put a date in the original draft. If 2/3 of the body wanted it at a different time, you're causing me no angst. I would leave that entirely to you all. I would tell you that the reason I chose November of 22 is because I recognize that August of 22 is occupied, and it was as good as any for me. But as long as it doesn't blow up a 2/3 majority, put it when you want it. That makes me happy. So thank you.
Representative Wheeler.
Thank you, Mr. Chairman. And as always, it's a pleasure to have you here, Mr. General.
Representative.
I just skimming through this case very fast, at which I am not much good. I see that there are multiple concurrences and some dissents. The dissents seem to make more sense to me. And as I understood it, it's found that the laws that the legislature had passed had given agencies authority to make administrative regulations, and another statute gave those the effect of rule of law, which in the dissent, I think by McFarland, said, but those statutes were unconstitutional in themselves. So any regulation by the legislature of those rules is ineffective because those laws were void ab initio. Now, those are the dissents in which I think my representative from Douglas County was suggesting that maybe amending the statute. But if we don't do that and we just put a general proposition on the ballot such as we have, is there any fear that once we do it, it's going to be challenged and it's stare decisis?
Representative, I think the short answer to that, at least from my vantage point, is no. And let me unpack what I mean by that simple one-word answer. I don't think there's anything here that I can foresee that increases the risk that a statute might be construed as, if I remember correctly, I think that that language is talking about the unlawful delegation doctrine, that the legislature didn't have the ability to give away its legislative power in the first place. Therefore, you also don't have the ability back in 1984 to veto its use. But because the statute was an unlawful delegation and invalid ab initio, we don't get to the second question. That, of course, as you point out, was the dissent. It wasn't the prevailing rule, but nonetheless, there's nothing here that I can see that alters the threshold delegation analysis and issue. It makes it not worse, makes it not better. I suppose it adds another tool where you all could reject something that you believe is an unlawful delegation without, as applied, without, you know, having to go through litigation on it. But I don't want to oversell that. That's not the purpose. The unlawful delegation doctrine, in the first place, as you know, is the subject of lively ongoing debate in the Kansas courts. Justice Stegall had I can't remember if it was a concurrence or the opinion or a dissent. I can't remember. It was a few years ago. It was the case, I believe, from the judge in Southwest Kansas. Doggone it. You know what I'm talking about. Anyway, I may be mixing up my cases, but he did I thought, a very nice collection of the history of court cases on unlawful delegation in Kansas from about the mid-20th century forward. And my words, certainly not his, ultimately concluded it's a real hash. It's hard to read the cases and know what the law is. So certainly it's possible, depending on which branch of that, you know, would prevail going forward. You could still have unlawful delegation problems. I just don't think this makes that more or less likely.
Thank you, General. I appreciate the response.
Representative Keither.
Thank you, Mr. Chairman. I don't have a question, but I don't know if it's the appropriate time now or when we're going to work the bill to really walk the committee through what Rules and Regs Committee does before because most people don't always know what the process is and how it works. So I think a little education would be necessary before we do anything with this, or at least that would be my request, and you do it at the appropriate time. Thank you.
Sounds good. We'll have Natalie or Bob get ready for that. Representative Humphreys.
Thank you, Mr. Chairman. Thank you for being here. So just so I understand, if this were to pass, what passes is it allows the legislature to establish procedures to revoke or suspend rules and regulations that are adopted, blah, blah, blah. So what will that look like? I mean, who, you know, say it does pass, and then is it the Rules Committee that starts figuring out how we're going to do this, or is it the joint rules of both bodies, or what would that look like?
So the proposed language of the constitutional amendment, if you look at line 1, 2, 3, 4, 5, including the title of section 17, you'll see that it would authorize the legislature to provide by law for the revocation or suspension. So it wouldn't be, I don't believe it would not be an exercise of rulemaking power, wouldn't be a committee function in the final analysis. It would be enactment of a statute, sort of back to Representative Carmichael's point, that would be the implementing legislation that says, here is the procedure by which this power is to be exercised.
Okay, that's super helpful. And then who might oppose this, do you think?
Well, I hate to speculate. I don't know. I was very pleased that there were no opponents for the hearing today.
Right. Okay, thank you. Thank you, Mr. Chairman.
Taking a chance here, but back to Representative Carmichael.
Thank you. Very quickly, just one thing we ought to keep in mind, though. The revocation typically in a scenario like this is not by statute, because a statute would be subject to a gubernatorial veto. And I think the way this amendment is worded, it might be more analogous to a resolution process, such as you mentioned an ERO. Do I understand that correctly?
Representative, you do, and if I was unclear, I didn't mean to be. I believe should this pass be on the ballot and pass, the legislature at that point would need to decide whether it wishes to exercise this authorized power. If the answer to that is yes, you would need to pass a statute, a law, that sets up the mechanism for this power to be exercised. But assuming that happened, the actual exercise of this power, in order to be consistent with the amendment, would be by a concurrent resolution. It would be by a majority of both houses.
And I apologize, you probably said that, I just heard it differently, but thank you for educating us a little bit farther. Thank you, Mr. Chair.
Any further questions for the proponents? Not see any. Anyone here today as a neutral? What about an opponent? Okay, hearing is closed on HCR 5014. opening the hearing on House Bill 2412. And Natalie, could you give us an overview, please?
Thank you, Mr. Chairman. House Bill 2412 enacts the Kansas Fights Addiction Act to establish a grant program for the purpose of preventing, reducing, treating, and mitigating the effects of substance abuse. Section 1 names the act, and Section 2 provides definitions to be used throughout the act. Section 3 provides that the Attorney General would remit all monies that are received pursuant to opioid litigation to the Kansas Fights Addiction Fund, which is also created here in Section 3. That money would be used for grants approved by the Kansas Fights Addiction Grant Review Board to qualified applicants for projects and activities that would prevent, reduce, treat, or mitigate the effects of substance use. Section 4 creates that Kansas Fights Addiction Grant Review Board. That would be under the jurisdiction of the Attorney General. The board would have 11 members. At least one member from each judicial district. The members would be required to have expertise in prevention, reduction, treatment, or mitigation of the effects of substance abuse. The bill also provides for the appointing authorities for all of those members. Action by the board would be by 6 affirmative votes, and the board would be able to adopt rules for its procedures and operations. The board would receive and consider applications for grants, and in awarding those grants, the board shall support services throughout the state, take into account science and substance abuse prevention strategies, consult with appropriate public and private entities to ensure coordination of drug abuse and addiction, prevention and mitigation throughout the state, approve grants only in compliance with the requirements of Section 3, and consider the sustainability of programming after those grant funds are exhausted. The board would also be allowed to establish conditions for the award of grants and require assurance and subsequent review to ensure that those conditions are satisfied. They would be able to give preference to qualified applicants that are not otherwise seeking or receiving funds from the opioid litigation. And they could give preference to expand the availability of the Certified Drug Abuse Treatment Program. The Attorney General would provide administrative support to that board, and they would be able to enter into agreements with the Sunflower Foundation. Subsection D provides requirements for those agreements if they did that. Members of the board would not receive compensation or expenses, and they would be required to file a statement of substantial interest. No member would be able to participate in the consideration of any grant for which the member had a conflict of interest in that grant. Section 5 provides that the Attorney General in each municipality shall be solely responsible for paying the costs of opioid litigation brought under their respective authorities, and they would be able to seek payment or reimbursement of those costs that are not subject to the requirements of Section 2. Section 6 provides that on and after January 1 of 2021, no municipality shall file or maintain opioid litigation in any court without the prior approval of the Attorney General. And if a municipality already filed that litigation, it would be required to withdraw that litigation unless the municipality receives approval from the Attorney General. This section would not apply to litigation that was filed prior to January 1 of 2021. Section 7 provides that no later than March 1st of each year, the Kansas Fights Addiction Grant Review Board would submit a report of activities to the Speaker of the House, the President of the Senate, the Governor, and the Attorney General. The report would be required to include an accounting of monies deposited and expended from the Kansas Fights Addiction Fund, a summary of each approved grant, an explanation of how the board's actions have complied with the act, and any other relevant information as determined by the board. And I could take any questions.
Any questions for Natalie? Do not see any. We'll start with proponents and welcome back the Attorney General.
Thank you, Mr. Chairman, very much, and committee, and thanks for having Attorney General Day at your committee today as well. We appreciate your hearing our bills. So let me start off. This is an odd place to start, but it may perhaps be helpful in the analysis here. There are really two major policy decisions that we're presenting to you here. I mean, there's lots of smaller ones, of course, but there are two big ones, and I want to be sure to highlight that because I think that some of the dynamics of support and opposition and concern may be different from one to the other. Most of this bill is about trying to create a vessel into which I can put monies recovered by the state from opioid litigation, I'll talk about that in a moment, and create a mechanism for that money to be spent on opioid abatement services. That is what most of this bill is about. And obviously it's up to you, not to me, but I would nearly beg you to please enact something this year that addresses that issue, because otherwise I'm going to have significant amounts of money we have recovered through litigation that I'm required by court order to cause to be spent on mitigation purposes, drug abuse treatment or related, and no mechanism to cause that to happen. So that's the most important piece of this. The other piece of this that's a major policy issue that is not necessary to accomplish what I just described, but I still think is wise public policy, but I recognize the dynamics are different, is Section 6. Section 6 seeks to extinguish future claims, the bringing of future lawsuits by public entities in Kansas related to opioid litigation. And from my vantage point, at least, the purpose of that is to try to maximize the state's recoveries, more dollars in some of the pending cases. So I'm going to talk about both, but I just want to, they are in fact two distinct matters. Could have brought them as two bills, but because they're both related to how we handle our litigation, they're together. I wanted to be sure to acknowledge that. With respect to the major purpose of this bill, so here's sort of the history on this. You all are well aware that in recent years, many entities have either brought lawsuits or otherwise are participating in the resolution of claims against a variety of entities, companies that we've accused of unlawfully fueling addiction through the marketing or other aspects of that led to the overuse of opioids and caused tremendous harm to individuals and to public budgets. The state of Kansas, through our office, is a full participant in that. We have actually reached an agreement in principle with Purdue Pharma. It's a settlement framework agreement. Purdue then went into bankruptcy, so even though we have a framework, we're now slogging it out in bankruptcy court, have been for a couple of years and will be for a while yet. So no money actually has flowed from the Purdue case yet. We also have reached an agreement in principle, a settlement framework, with respect to Mallinckrodt Pharmaceuticals for what we accused it of. It also has taken its way into bankruptcy court, and so we're slogging it out in bankruptcy court, and no money has flowed from that yet. But I want to acknowledge that those two did happen and are still pending. We then reached a settlement agreement with Mckinsey and Company, which is one of the largest consulting firms in the country. Essentially, if you boil it all down, we accuse them of unlawfully participating in the inflated marketing of opioids that led to the overprescription and caused an addiction crisis. We have reached a settlement, as have other states, with Mckinsey for that conduct. And they are not in bankruptcy court. And my expectation, has that been approved yet by the court? That has now been approved by the court, so my expectation is there is going to actually be money coming from that. If my memory serves me, it's a total of, I think for Kansas, about $4.8 million, and I believe it's paid over 3 years with 5 years. 5 years with a balloon up front, and then it ramps down. That's really what's causing us to bring this legislation now, because in the short term, I have to have some place to put that money. And as part of the settlement, as is true in all of these cases, the parties generally are focused on getting a provision in the settlement. It's very important to some of the parties that requires those funds to be used for abatement purposes, or at least many of them to be used for that. And there are reasons for that, but generally speaking, there are parties at the table who are very concerned that this money goes to a public entity and gets siphoned off to their general fund. And now we've done nothing to try to change the cycle of addiction, which is what got us to this mess in the first place. And in order to agree to settle these claims, some parties are insisting that be so. In any event, that's where we are, and that's why we need a mechanism to receive and distribute that money consistent with that purpose. What we've proposed here, it's not magic, we think it's sensible, is the bill creates a pot, a fund. We deposit the state's share of that money in the fund. We leave undisturbed local recoveries, which is a different issue that's been very tricky in all of this, not just in Kansas, but nationally. And then this would set up basically a grant board, and any public or not-for-profit entity can go apply for grants from that pot of money, get the money, and use it for the approved purpose. There's no magic to how we've composed the board. There's no magic to the structure. We just need a vessel to put the money in and a mechanism to get it out to the approved purpose. And this is the best we've come up with at this point. That really is sort of bottom line. That's what this is about. We tried to create a mechanism that will be evergreen, that will endure, because I believe there are going to be other settlements or other judgments, some of which I hope are going to happen before you all return in January. And rather than have a case-by-case statute, we wanted to create a common mechanism. So if we recover more money from a different defendant in September, the law tells us what to do. We put it in the same pot. There's a mechanism to get it out for the same purposes. And we don't have these sort of interruptions and ad hoc dealing with this. So that's what we're trying to accomplish here. I do want to very much thank, there have been a lot of parties at the table. I know some who are members of this committee, and I particularly want to thank the cities and the counties. I don't mean to leave others out, but they've been great, because, you know, this has been a very tricky matter because everybody rushed to the courtroom. By the way, this bill is not about that, but they did. I mean, I think there are 2,700, something like that, cities, counties, other municipalities, states that are suing these same defendants. And some of them, like the state of Kansas, I made the decision, we handled it in-house, so we didn't have to pay private counsel. Others made different decisions. That's a debate for another day. That's not what this is. But you know, we have a large case that we've been working on for years on this, and I can say with confidence we're there on the substance. We're hung up on how we're going to pay 2,700 different plaintiffs' attorneys' fees, and what pot that, not your problem right now, mine. That's been a point of difficulty between the different plaintiffs, local and state, and in Kansas, our municipalities and counties have been great in trying to work through that. We have shared objectives to just get it right. So anyway, that's the major part of this bill. The other piece on Section 6, let me explain to you why we're proposing it. I recognize it'll have different dynamics. But in at least some of these anticipated settlements, I'm thinking of one in particular that I think is very close. It's not, these are not simple sort of resolutions. These are not, 5-page settlement instruments. And there is going to be, in at least some of these future settlements, a provision which is insisted upon by the defendants, the companies, that creates incentives for states to extinguish as many ongoing claims against those defendants for the same past conduct as possible. Well, that's easy for the state to do as a state. I can sign a deal that says, on behalf of the state of Kansas, we're not going to sue you further on this. But I can't independently waive the claims of 600 and some cities in Kansas or 105 counties. And while many of the local jurisdictions are already litigating, and that's fine, those cases will get resolved somehow, what we worry about is there are still many that are not litigating, but I'm pretty sure they're going to be litigating if their claims don't get released. I mean, there have already been, I was told the other day about a municipality in Kansas that was approached by, plaintiffs' counsel shopping for business, which is their right, within the last 3 weeks on this case. The case is done. There's no work to be done. It's finished, except for sorting out who's going to pay the lawyers. The last thing we need is more lawyers at the table, right? I mean, that's an opportunistic move. So perfectly lawful right now, but opportunistic. Our goal with this language is to be able to say Kansas should recover the maximum amount under that sliding scale that rewards extinguishing claims, because we have extinguished them all. Now, if you don't want to do that, that's a policy choice for you. I want to be sure you understand that the result of not doing something like that is likely to be a reduction to some extent in the state's recovery. I can't quantify it right now, and I'm not saying the sky is falling. I just want you to understand that's the trade-off. So with that, Mr. Chairman, I'd be happy to stand for questions or stand aside.
Yeah, let's hold on a minute. We'll see where we get and then come back with questions.
Great, thank you.
Stuart Little. Thanks for still being here. I know you need to get out of here.
Oh, no, you're moving very briskly today, so that's awesome. Stuart Little, I'm with the Behavioral Health Association of Kansas on behalf of them today, in support of the vessel side of the issue of this bill that the Attorney General laid out. I work for a group that provides substance use disorder treatment services around the state. There's a map of our membership in there. And obviously through the pandemic and through the everything that folks are doing in terms of substance abuse and drug use and mental health issues and those kind of things, we're interested in getting the support we can to provide treatment to any of those folks. This is a proposal to set aside the resources that would be added to the fight that we are all engaged in around the state to help folks deal with addictions. And we're supportive of the bill that sets that up. Because we need any of those kinds of resources. There's a couple of comments that I note in my written testimony that I would mention just for consideration. One of the things that's really good about this program is it's available for treatment services. It's not limited to just opioids. It's not limited to folks. It's going to be broadly speak to addictions. And it includes the ability to use this for the Senate Bill 123 program without supplanting it. We would never want to supplant that, but as more offenders make use of that, that would be beneficial. I do note in one section, there's a reference that a qualified applicant does not include a for-profit entity. I would note for the record that there are lots of for-profit entities that are licensed by the state of Kansas and provide services, Medicaid services, state grant-funded services, participate in the Senate Bill 123 program. I'm unclear why for-profit organizations are excluded from participating as a qualified employee or participant. The last issue I would mention is that not that the amount of money here that's on the table right now is insignificant, but the state and has invested significant resources in substance use treatment services around the state. And if this is now in a single-digit millions conversation, this is a great way to get resources to more folks. If I don't know what not being an attorney and what we're in line maybe to get, if this is a vastly significant different amount of revenue, there may be some need to talk about connecting this back up with the structures and systems we already have in place that handle federal and state monies. But I don't know what that threshold is, but it's just something that stays in my mind. I'd be happy to answer questions at the appropriate time.
Thank you. Michelle Ponce.
Good afternoon, Chair Patton and members of the committee. My name is Michelle Ponce, and I'm the Associate Director for the Association of Community Mental Health Centers. We represent all 26 licensed community mental health centers across the state who provide services to all individuals needing them regardless of ability to pay, and that makes them the safety net for the mental health system in Kansas. We appreciate the opportunity to testify in support of House Bill 2412. Kansas has not been immune to the impact of the opioid epidemic that has plagued our country, and our community mental health centers are on the front lines of the response to that epidemic. Currently, about 3/4 of them already provide substance use disorder treatment and services, and we anticipate that over the next few years, as community mental health centers transition to the certified behavioral health clinic model, that number will only increase because substance use treatment is a required component of that model. From this perspective, we very much support the intent of the bill to provide funding through a grant process to qualified local programs. We appreciate the allocation of an appointment to the newly created Grant Review Board. As the bill is currently written, one appointment is to be made by our association in consultation with the Kansas Association of Addiction Professionals. It should be noted that our associations are separate legal nonprofit entities, each with our own governing boards, and we each bring a slightly different perspective. Our association's perspective is based on a broader behavioral health focus, while CAPS is specific to addiction and prevention treatment services. Given the two distinct perspectives, we respectfully recommend each association be allotted its own appointment to the board. In conclusion, we do applaud the plan to distribute funding in such a way to best meet the needs of our local communities, and we look forward to contributing to the work of the Grant Review Board. Thank you, and I'll be happy to answer any questions you may have at the appropriate time.
Very good. Thank you, Michelle. And hopefully the third time you testify before us, I'll get your name correct. I even wrote it down wrong again this time. Let's see, Deb Stidham.
Good afternoon, Chairman Patton. It is my pleasure to be here today to speak in favor of House Bill 2412. I am here representing the Kansas Association of Addiction Professionals, Kansas's only nonprofit addiction prevention and treatment provider trade association since 1974. CAP's membership includes agencies located all over the state, providing an array of services from outpatient to residential. We do support this initiative by the Attorney General, creating the Kansas Fights Addiction Act. This measure provides for the expenditure of funds received as a result of opioid litigation and to apply them to the abatement or remediation of substance abuse and addiction. So I just want to point out a couple of things that haven't already been talked about that are in my testimony. So nationally, experts have provided principles to help states as they make funding decisions and policies supported by these settlement funds, many of which are already part of this proposal. Number one, we want to be sure to use evidence to guide spending. At this point in the overdose epidemic, researchers and clinicians have built a substantial body of evidence demonstrating what works and what doesn't, and we should use this information to make those funding decisions. We should also invest in youth prevention programming and supporting parents in need. Kansas should support children, youth, and families by making long-term investments in effective programs and strategies for community change. Number three, we need to utilize the recommendations cited in the 2020 Legislative Mental Health Reform and Modernization Committee. Those recommendations identified were developed by a consensus from a wide range of stakeholders in the behavioral health field. And lastly, we need a fair and transparent process for deciding where to spend the funding in Kansas. And this process really should be guided by public health leaders and those in the behavioral health field. And while I know some of those are certainly mentioned for the Grant Review Board, I just ask the committee to consider how to refine that process a little bit more. You will find these principles and the professional organizations that support them at Johns Hopkins Bloomberg School of Public Health. I've also attached some information for the committee from the National Institute on Drug Abuse titled Kansas Opioid-Involved Deaths and Related Harms that may be helpful. So in summary, this legislation will help ensure that the funding is spent on evidence-based care for people with substance use disorders. And given the widespread budgetary shortfalls caused by the COVID-19 pandemic, I urge the legislature to avoid using the settlement monies to address budget gaps and to align them with the legislation presented here. On behalf of CAP, I would also encourage you to consider specifying that those making the appointments to the board seek out, where possible, appoint addiction professionals. Thank you very much for your time this afternoon. I'd be happy to answer any questions at the appropriate time.
Committee, you have written proponent testimony from the Kansas Association of Counties and the Kansas County and District Attorneys Association. Anyone else here or online as a proponent? Okay, let's go to questions. Representative Carmichael.
Thank you, Mr. Chairman. As you might presume, perhaps some questions for our Attorney General if he's still in the room.
He's hanging out with us.
It's always good to have a former legislator come back to see us. How much money are we talking about? And I understand that there's 2 or 3 different answers to that question, but just initially, how much money are we talking about now? How much are we talking about maybe in the future? It's, I think, Mr. Little's question, but I'm asking it.
Representative, hard to predict. I'll tell you what I know, and it'll give you at least a sense. So under the Mckinsey Settlement, which is real and court approved and coming, that's $4.8 million, apparently spread over 5 years. That's what's happening now. The Purdue Settlement, what's publicly available on that for the overarching? The Purdue Settlement that we agreed to the framework, and we're now in bankruptcy court with them, is about $4.3 billion overall. But remember, that's spread among many plaintiffs. And they're in bankruptcy court. So that's that. Malincrot? Don't recall. I have to check. I don't think it's the big one, the really big one that's pending that I've alluded to a couple times. I believe we are close, at least I'm hopeful we are close to reaching a settlement with the 3 major distributors, McKesson, Cardinal Health, and Amerisource Bergen. That top line number's been reported, hasn't it? Yeah, so public reports show that that is about a $26 billion settlement globally. We are, however, that's the one we're hung up. We generally are in agreement among the plaintiffs and the defendants on how much money, what the formula is in the sense of, you know, rewarding greater extinguishment, as I alluded to, of claims, all that kind of stuff. But we aren't yet there on agreement of how to pay the plaintiff's attorney's fees for those entities that either hired counsel and owe them when this is all done, or you know, a few of the large states dedicated large amounts of in-house staff for a period of years to this and would like to be reimbursed for that. The number is in the billions of dollars that is in dispute on attorney's fees. And so I don't know how much comes off of that 26 billion that would remain then to be spread by the states. Is that all fair, Chris? Yeah, okay.
At least that gives us a concept of how much money we are talking about right now, roughly $1 million a year for the next 5 years, but with the expectation there will be substantially more money come into this Sunflower Foundation if this legislation is successful. Generally correct?
Yes, Representative, and I might, it might be helpful if I also added, because I didn't say this, obviously each of these settlements is structured differently because they're individually negotiated. With respect to the big one for the distributors, it contemplates, whatever the Kansas share ultimately is, it contemplates that being paid out over a period of years that is greater than 5 years. I don't know where we've settled, but it's around 12 or 13 years. So it shouldn't be, shall we say, a disproportionately large splash of money all at once. It should last for a period of time, but it's not like tobacco. It will go away at some point. It is a finite payment schedule.
And I appreciate that distinction. Thank you. I understand it's a terrible predicament to be a lawyer, to have money coming in and not know what you can do with it yet. And so I feel for you, Mr. Attorney General, I really do. But you know, as it relates to COVID funds and the like, unexpected money that showed up on our doorstep, we've been talking about turning the authority for that over to maybe the Legislative Coordinating Council or maybe the State Finance Council. I read Ms. Roth's testimony. She seems to be concerned that the board you plan to put together has 3 prosecutors, no defense lawyers, and I've heard the testimony of other conferees this morning being concerned that, or this afternoon, that they want to get more services-oriented people on this. And I also heard you say your real concern isn't how we make up the board, it's more that we have some way to distribute the money. So why don't we just let our established designees of legislative authority, or maybe even better, let's put all this in a fund, and then the legislature can come back next year and we can cut up this legislative work. Why do we need to do it this way?
Representative, you know, bottom line is you could do either of those two things. I think they each carry, you know, a different set of challenges, but those are policy choices. Obviously, if you wanted to use an existing entity like the LCC or the Finance Council or something like that, you didn't say those specifically, but if you wanted to use some type of existing entity, you could. Our thought here was, as you know, some of the other conferees suggested, because of the specific nature of this grant funding, it seemed sensible to us to have the folks making the grant review decisions have particular expertise in how it's used, substance abuse treatment or Senate Bill 123 implementation or monitoring. And yeah, I'll repeat, I'm not wedded to the structure, the composition here. If you want to add others or take some off, just as long as it functions, it makes me happy. Not that that's your overall purpose, but I mean, it still satisfies my need. You know, if you wanted to put this in a pot and have the legislature appropriate it, you could. I would, you know, not recommend that, although if that's what the legislature wants to do, you can. As you know, the challenge with that is when money's in a pot and budgets are tight, there often is a temptation to appropriate it for things outside its intended purpose. And, I would advocate very strongly, because it was a condition of these settlements that these monies be used for their intended purpose. And so I would think a structure like this could better insulate that, not perfectly, but better. But that's ultimately a call for you all to make.
And Mr. Attorney General, I certainly agree with you that probably putting this in for appropriation by the legislature, and for that matter, the LLC and the Finance Council, might not be the best way to do it. I'm just, for purposes of our discussion, I just want you to be able to educate folks as to why you picked this alternative as opposed to others. But your answers do raise questions about the nature of the recovery from Mckinsey. I will confess to you that I have not had time to read your settlement agreement that you entered into. I apologize for that. But I think what you're proposing here is that we use these funds pursuant to the settlement agreement because apparently it requires mitigation. In other words, future remedial action or future prevention efforts. Whereas I had understood, for example, the significant litigation that's pending out of my county, Sedgwick County, in a federal forum, deals with compensating my county for the hundreds of thousands and millions of dollars that we've spent on treatment, that we've spent on EMS, that we've spent on a whole host of things. Is this only prospective going forward? Or is this money that you've recovered going to help my county out in meeting the expenses that we've already had to pay for?
Well, Representative, you have now put your finger on what has been perhaps the trickiest issue in, other than attorney's fees, in these settlement negotiations, and that is the asymmetry in the nature of the claims by different groups of plaintiffs. And, Mckinsey was just a separate settlement, but the distributors got MDL'd, and, we've been in Cleveland in front of Judge Polster on that, and you've got all these disparate interests trying to come up to a common resolution. Let me start at the beginning here, which is the Mckinsey settlement, which is the money that's actually on the table now, or soon will be. That is actually an easier one to resolve with respect to your question, because there is no local claim there. Local claims survive. If the locals want to go sue Mckinsey on some type of theory, God bless them, they can. We have resolved only the state's claims as to Mckinsey. They're actually, I'll say technically, we could have put the recovery money into two pots. We could have put one into future abatement and another to the Attorney General's office to reimburse our litigation and investigation costs. I made the judgment call. I wasn't even going there. I don't want to be defending why we're putting money in the AG's bucket. It wasn't that much money, and let's just put everything into a common pot that others can apply for. That's Mckinsey. That is not overall. Now, going forward, as we get to, for example, the distributor's settlement that is, I hope, close but not done yet, it is much trickier. The current framework, this has all been discussed publicly, hasn't it? 3 buckets. That's all been in the public domain. The current framework that's under discussion, again, to resolve 2,700 plus very disparate claims, some wanting money to backfill a budget for costs, as you point out, that were incurred in the past, others wanting the principle of this is a one and only opportunity. We ought to use this money to break cycles of addiction going forward so we don't recur, some of the harm. Yeah, there are, the framework contemplates what's come to be called 3 buckets, that a certain amount of money that's recovered would go strictly to local jurisdictions with flexibility to use it essentially however they want. And we don't propose to extinguish that here. You'll notice that the only money that goes into this common pot under this bill are state recoveries. We deliberately left local recoveries outside of it because that's where we got into some really difficult, good faith, but difficult discussions with our friends representing the municipalities and the counties. And I just didn't want to bite that off right now because I need something to pass. So that was the concept there. Leave their bucket to them and they either get it or don't based on their current litigation posture. Or, well, that's a whole different issue. So that's bucket number 1. Bucket number 2 is money that would come to the state and would be unrestricted. And it is possible at least under the terms of the framework of that particular settlement as it stands right now, that there would be some amount of money that would come to the state, and you could put it in the general fund without violating the court order and spend it on widgets if you wanted to. It's not the lion's share of the money, and my recommendation here is don't even try to account for it separately. Just put it in the common pot and let folks dealing with addiction and mitigation and abatement issues access it. Because it wasn't money we were counting on. It's not a huge amount, and it's easier than trying to sort of split the pots. But that's policy judgment. And then the third pot, which is the big one in that particular tentative settlement, is the abatement pot. I don't remember the number, but I want to say it's like about 70% of the total under the terms of the settlement agreement would be dedicated to abatement. And that would be the core abatement money here. It would come to the state, go into the grant pot, and be eligible for folks to apply for it. So I really don't mean to filibuster. It's a lot of moving parts.
And Mr. Attorney General, I very much appreciate that this is complex, and it's part of why I asked the question. I appreciate the chair's patience with it. The final thing I would like to ask, though, with the chair's permission, of course, I don't want to imperil the recovery of damages by my county for the millions of dollars that they have spent because of what these defendants allegedly did. And I understand that you're making some reservation with respect to existing lawsuits down in Section 6. But where my concern, and you even pointed it out, there's two parts of this bill, and I don't have a lot of problem with the top part of this bill. We may figure out who hands out the money. But the second part, Section 6, we're going to hear testimony from folks who see it differently than you. I want to give you a chance to address their concerns now while you have the opportunity. What are you doing to make sure that we don't extinguish claims such as those brought by my county already, but as importantly, other claims going forward? Because it looks like you've got veto power under this bill.
Representative, I anticipated you and I might get to discuss Section 6, and I thought of you when we drafted it, because I know we've discussed these issues in the past.
And by the way, this is a much better bill than what we looked at last year in a broader scope, and I appreciate your consideration of many people's concerns.
Thank you, Representative. So, I recognize that there are different policy dynamics on Section 6. I do understand that. As I said, the reason I felt I had some obligation to bring it forward, and then you all will decide if you want to do it or not, is if I didn't, and then we get to the back end, for example, of the distributor's settlement, which I believe is going to have this sliding scale of recovery for the state in particular, not only the state, but my client, the state, that maximizes our recoveries based upon how many state subdivisions release their claims. And I didn't at least try to get you to release all of them so we get, the maximum recovery possible. I felt like I would have been derelict. So that's why I felt the need to bring it forward. I do think it's a good idea, but I recognize, your point. I guess my assessment at this point, and others, may disagree, but look, if you're a government entity in this state and you haven't already gone out and figured out that there's a chance to try to retain counsel or whatever and bring a lawsuit to get your damages in the back, what have you been doing? I mean, the major entities that are likely to sue have sued. And that's part of the reason we don't have resolution yet, is we're all over the map trying to sort that out. That is what it is. And that includes, of course, Sedgwick County and the city of Wichita. And I don't know if there are any other cities in Sedgwick County that have filed. I can't remember that. But and I believe, and if we haven't, we're certainly open to wordsmithing this with other parties. I believe we have left them alone in terms of that portion of their recovery that they would be free under the terms of at least the distributor's settlement to use for whatever they wanted, filling a budget hole, reimbursing their general costs. They would not be free to use, for example, the mitigation funds. Will be judicially required to be used for drug mitigation going forward. They won't be free to use that, the 70% of the money, to fill a budget hole or backfill expenses. So I don't see how we have disadvantaged any local entity that's trying to recover spent funds by doing it this way. And that was certainly my, intent. Therefore, if you wanted to sue, you can. We want to extinguish that ability going forward with the safety valve of, if there's something we haven't foreseen and it makes sense to sue, there's a new and novel claim or something that shouldn't be extinguished, at least there's the ability to allow it. But at least under this proposal, we could then represent post-settlement. You got your global peace, which is the term that's been used in the negotiations. We want the maximum recovery. That was kind of the concept we were seeking.
Well, Governor, I appreciate Mr. Attorney General, I appreciate your explanations here today. We actually agree upon more than we disagree. Thank you, Mr. Chair.
Any other questions for the proponents? If not, thank you, sir. We'll move on to neutral conferees. Michael Koss is first. And I do know we have a couple committee members that need to leave to another committee, and you can always listen at home when you get home tonight. KU game, or go back and watch this on YouTube, but at some point be ready.
Thank you, Chairman, members of the committee. I'm Michael Koss. I'm Deputy City Attorney for the City of Overland Park. We are one of the 2,700 municipalities that is part of this litigation against the companies that were responsible for the opioid epidemic. We joined that litigation for three primary purposes: help fund substance abuse efforts, substance abuse prevention efforts, to help recover our costs that we've incurred, EMS, police, fire, related to the opioid epidemic, and hopefully achieve injunctive relief that would stop these pharmaceutical companies and other companies from bad practices. And that's the reason we like this legislation. We're neutral, but we think this is a really good first step. We think it promotes a sensible balance of preserving our home rule authority to continue our litigation on our own, if we so choose. But it also establishes a board that we think sets up a really good framework for getting potential settlement funds where they're needed to stop the opioid epidemic in Kansas. However, we do have one proposed amendment that we think that would drastically improve this bill. And we worked on this with a couple of non-litigating municipalities. We all thought that this achieved our mutual interests. And that is to create a separate fund just for municipalities to use for substance abuse. And the municipalities that could access this fund are, one, non-litigating municipalities, not like us, and then litigating municipalities that release their claims and allow the AG to settle on our behalf and administer those funds. And we think that's a good option because, one, municipalities have a great deal of experience administering funds related to substance abuse. As some of you may know, we receive funds from liquor by the drink sales, and those are restricted to substance abuse prevention. We have a lot of great relationships with local nonprofits, and we think that we could be similarly responsible with these opioid funds. And also, it would increase the chance of increasing the state settlement amount if there's more jurisdictions that waive their claims. As the Attorney General mentioned, Section 6 is largely in furtherance of this effort of having as many claims extinguished as possible in the state, and so you get a larger settlement. By creating an option for cities like Overland Park to join in the state settlement and release our claim, we would increase the overall state pot and work with the Attorney General about how we would administer those funds. Other states have adopted this model, and we think it makes a lot of sense in Kansas as well. And with that, I'm happy to take any questions at the appropriate time.
Thank you. We'll get back to you on questions in just a minute. Jennifer Donnelly on WebEx.
Thank you, Mr. Chairman and members of the committee, and thank you for the opportunity to provide neutral testimony on behalf of the Board of Pharmacy and the K-TRACS program in relation to House Bill 2412. As you may or may not know, K-TRACS is Kansas's prescription drug monitoring program and serves as a critical decision-making tool for Kansas healthcare providers regarding the prescription, regarding controlled substance prescribing. It is also a potent tool to aid in the identification of patients with drug-seeking behaviors, those patients that may need treatment, and to educate the public regarding controlled substance prescribing and dispensing in Kansas. Pharmacies are required to submit daily information to K-Trax for each controlled substance prescription dispensed to Kansas patients, including opioids. And if a prescriber or a pharmacist has a concern about a patient, they can look up that patient's prescription history in real time on the web-based K-Trax system using their private login credentials to maintain confidentiality. The impact of the K-Trax program can be measured in a variety of different indicators, including a 21.5 decline in the number of opioid prescriptions prescribed to Kansas patients since 2016, and a decline of 23.4% of prescriptions that have a greater than or equal to 100 MME or daily morphine milligram equivalent, which shows success in changing prescribing behaviors and patterns within the state of Kansas. In addition, the rate of multiple provider episodes or instances of patient doctor shopping behavior has also declined to 3.4 per 100,000 population. And all of this is utilizing information that we receive through the K-Trax program. Additional statistics can be found in our annual report, which was included in our written testimony. To assure the sustainability of K-Trax, the board is requesting the addition of a friendly amendment to House Bill 2412 to consider adequately covering the cost of operating the K-Trax program. As many of you know, the sustainability of the K-Trax program, the prescription drug monitoring program for the state of Kansas, has been before the legislature before. And the major justification is that this program's importance to public health and public safety professionals who need the prescription data to identify opportunities for the prevention, intervention, and treatment for the safety and of those patients moving forward. That's all I have today. I, again, want to thank you for this opportunity, and I also would be happy to answer any questions that folks may have at the appropriate time.
Thank you. Eric Sartorius. And Jennifer, Jennifer's back in the room. You're up next.
Thank you, Mr. Chairman, members of the committee. I hope the KU game is so out of hand in the first half that you can just turn this right on and have the game in the background.
I agree.
That would be much nicer than Saturday. I am Eric Sartorius, Executive Director of the League of Kansas Municipalities, and we are here to provide neutral testimony on HB 2412 this afternoon. I think what's really easy, and we can all agree on, is the legislature, local governments, residents, the Attorney General's office, we all have the same goal in mind, which is getting money to deal with opioid issues and get them out where they will do the most good. And then what you all are now left wrestling with is what is the best way to get there. In talking about this topic, one of the things we realized very quickly is that we have cities kind of all over the place on that. And that's why we're here neutral. We think it's an important policy discussion for you, but we're not endorsing a particular path to it. The money we do feel should be spent in both rural and urban communities. The language in the bill requires that an eighth of the funding go to each congressional district, which means that it still could tilt one way or the other a bit, even though both rural and urban populations have been ravaged by this. It is in the best interest of the state and the way that the settlement is being put together. It is in the best interest of the state and the cities and counties of the state to have as much release of future litigation as possible. But at the same time, cities and counties have to balance doing so with still protecting the interests of their clients, their residents. HB 2412, one of its unique characteristics compared to legislation across the country is that most others have set aside a specific portion for local governments as a way to incent that extinguishing of claims. And as you heard from Mr. Koss with Overland Park, several member cities have come together and have come up with a framework that we think could help alleviate some of those concerns of cities of why should I extinguish my claims when our residents have paid these costs. But with the framework Overland Park is laid out for other cities, they would be allowed to come back and have a pot specifically for local government, so they would know that they would have an opportunity for those funds. We think that doing so reflects the collaborative approach folks have approached this issue with. Just to get your arms around how quickly this money is probably going to go. This is not, and I think the Attorney General mentioned, this is not the same as tobacco settlement. It just isn't. I believe what he said was from one of the early settlements, about 4.8 million over 5 years. So if you want to put that in perspective, you just had testimony requesting a third of that money. So it's already out the door. So we would request that if you all are going to move forward with this, that you take consideration into creating a fee fund for cities and counties that would then incent them when they're being requested to extinguish any future claims. And I'll stand up for questions as well.
Very good. Thank you. Jennifer Roth.
Good afternoon. My name is Jennifer Roth, and I'm here today on behalf of the Kansas Association of Criminal Defense Lawyers. I wasn't sure what to call ourselves, so I said neutral, but most of you will know I'm pretty much anything but neutral. But as Representative Carmichael alluded to, we have put a lot of stuff in our written materials, our written testimony. So I just wanted to hit on a couple of things. And the first is that 2412 does embody a lot of the principles that I believe it's Ms. Stidham, I don't know if I'm saying that right. She referenced those Johns Hopkins coalition of 31 medical organizations who have put together this list of principles for people that are, or first entities that are making opioid settlement funds. And 2412 has a lot of those, but there's some that are missing. And one of the most important that I believe is missing is the voice of people who have lived experience. We see a lot of comments today, both in writing and out loud, about professionals, but there's also a way to be an expert from your lived experience. And that, I believe, is missing from this bill. People who have struggled with addiction, have a criminal record because of it, family members of people who have died. So I believe that 2412 needs to better embody the voices of people with lived experience. And there's actually an example in our written testimony from Massachusetts that basically says we can define expertise as being your lived experience. So that could be a person that's on the actual review board. It could be an appointment that's made by somebody already set out in the bill. Another opportunity is I realized further down in the bill that it talks about how the reviewing committee can talk to public and private entities with relevant information. And so maybe there's a way to further elaborate there that it includes people with lived experience. And I guess the second area that I would touch on that I wish 2412 would elaborate on, and that is the criteria for the grant money. I was wishing that when it lays out the things that the review committee will consider, I wish that it would be a little bit more explicit about including vulnerable populations, increasing the use of diversion, not just things that happened after you get convicted. Right now, Senate Bill 123, if I'm correct, only covers people that have been convicted, but there is a bill that this body has passed that would include people on diversion. I also have been thinking about what it means, what does mitigation mean? And is it possible that there could be some funding for people, could a grant program that helps people get expungements be a way to mitigate the impact of this crisis? So at any rate, the Johns Hopkins principles elaborate a little bit more on what should be included in criteria for this money, and I just asked this committee to take that into consideration. And also, I didn't mention youth or the racial impact, but that's another sort of lived experience that we are hoping can be included in the people that make these decisions and get these grants. So with that, I would stand for any questions, whatever the time is.
Very good, thank you. Any other neutral conferees? Okay, committee questions for any of the neutrals? Do not see any. We will move on to opponents, and we have Mike Fleming with us on WebEx.
Thank you, Mr. Chairman. I'm a Creighton grad, and we tip off in about 15 minutes, so I'll be very, very, very brief. I am a private attorney in the Kansas City area. I'm a member of the Kansas Trial Lawyers Association, and I am also counsel of record with others on behalf of Bourbon County in a lawsuit we filed almost 3 years ago in connection to the opioid epidemic. I appreciate the Attorney General's explanation and kind of separating this bill into two parts. The focus of my comments are on Section 6. And specifically, I think that there are some constitutional issues in that it violates home rule because it amounts to an unnecessary intrusion of the Attorney General's office into local government's abilities to determine their own affairs. You know, I think it's almost without precedent that a local government would have to seek permission from the Attorney General in order to protect its rights. I know the Attorney General said, hey, if you haven't filed a lawsuit by now, what are you doing? I've had conversations with many local officials in 2018, 2019. At the time, getting involved in litigation was just not a priority. Maybe it is now, but we shouldn't extinguish their ability to proceed simply because the Attorney General wants to resolve all these cases in one fell swoop. The only thing that should extinguish their rights are whether or not their claims are time barred. That is to say, when the statute of limitations expires, if they haven't filed by then, they're out of time. But you know, I think it might be appropriate to split this bill into two parts, to have the fund section as one bill, and then to address Section 6 in another bill. I know that members of my team that have filed lawsuits on behalf of municipalities and counties in Kansas would be happy to sit and visit with the Attorney General's office about the language in Section 6 to see if we could come to some mutually agreed upon language. But having said that, we would ask the members of this committee to reject this bill as it stands because we think there are constitutional issues in Section 6. Thank you for your time and consideration.
Questions? First of all, any other opponents? Okay, any questions? Not see any. Thank you all. We'll close the hearing on 2412. As you all know, time is short. This is the last week for committees to work bills, so I encourage you all to get together and try to come up with some possible solutions if we need amendments. So get to work. Committee, for tomorrow, we do not have time to work bills, obviously, today. So the list is growing for tomorrow. We have one bill hearing tomorrow. Dean Concannon from Washburn will be here to give the same presentation that I assume he did last year on a bill that deals with the Code of Civil Procedure. Riveting testimony we're going to get, so be ready for that. Then we will work some bills. So we have Senate Bill 4, Senate Bill 106, House Bill 2366, Senate Bill 60, Senate Bill 204, Senate Bill 283, Senate Bill 56, Senate Bill 172, and HCR 5014. That should give us enough work for tomorrow. Then Wednesday, I'm hoping, I had a bill request in tax today for some litigation that we need to make some changes to statute potentially. And if we can get that routed to us, we will try to have that hearing on Wednesday, and I'll give you more details on that tomorrow, what my plan is with that. But that list is hopefully what we'll start with tomorrow. So if you've got amendments, I know many of you do, let's try to have those ready so we can work those bills tomorrow. Thank you all. Have a good evening, and go Jayhawks, and I guess Creighton as well, at least for this round.